Right. Sri B. Sengutuvan.
Honorable Speaker, I am most obliged to you, sir, for affording me this opportunity to address this august House on such a matter as of crucial importance as the repealing and amending Second Bill 2014. The government has introduced a bill in which a host of, I think, as many as 90 statutes and 2 more which are amending acts. Most of which are amending acts, which are proposed to be repealed. And 2 of them are by way of errors that have crept into the amendments by inadvertence, as stated in the Statement of Objects and Reasons. It is one of the objects and reasons also state that it is one of the periodical measures by which enactments which have ceased to be operative or have become obsolete or are unnecessary are repealed, and by which formal defects detected in the enactments are corrected. Sir, it is learned that the Law Commission has recommended in its interim report dated September 2014 that as many as 253 laws have to be repealed as obsolete, and 34 of already repealed laws do find themselves in the government website. The Law Commission, once again, headed by its chairman, Chief Justice A.P. Shah, retired, has urged further to repeal all the appropriation acts which are more than a decade old, and they number as many as 700. And we are in agreement with the government with the recommendations of the Law Commission that obsolete laws are like dead wood, and laws have to be kept in a state of good repair, and pruning has to be done of what is totally unnecessary, obsolete, because they are a dead weight and they occupy the pages of the law books without any purpose and confound the public like the proverbial will-o'-the-wisp. From a cursory perusal, it is obvious that the various provisions of the amending acts which are sought to be repealed have already become incorporated into the main acts and have become either substantive or procedural laws of the country. Therefore, these amending acts are spent force, and they no longer require to be placed on the statute book. In the acts, these provisions have already been incorporated, and amendments are indicated by way of footnotes in the main acts. Therefore, the retention of these amending acts are redundant and superfluous, and they serve no useful purpose. It's my submission that, sir, law must be in such state of trimness as to command obedience from all those who come within the purview, howsoever high and mighty he might be. The country that has laws which are not obeyed is not served by rule of law. The primary duty of the legislature is to enact laws when such a thing is called for, and to repeal them when it is no longer in use. So therefore, we are in agreement with the government that these useless sets of acts have to be repealed as they serve no useful purpose. And at the same time, the legislature is obligated to the people to codify certain laws also. For instance, Article 141 of the Constitution states that the law declared by the Supreme Court shall be the law of the land. There is a plethora of decisions of the Supreme Court which need to be codified. And as a matter of record, our criminal statutes, primarily the Indian Penal Code, Criminal Procedure Code, and the Evidence Act, which govern the criminal procedure and the substantive criminal laws, are geriatric, and they also need to be trimmed and new amendments have to be brought in. So in fine, I support the initiative of the government that comes at this late hour, and we support the move of the government. Thank you so much.